Well, I have in my notes that the 1910 collective reading of Cruikshank emerged and became the norm.
Okay, so for much of the 20th century, the way people argued about the Second Amendment is it an individual right or a collective right?
Which models the dichotomy today.
Which models the dichotomy of gun control versus gun rights. Although I think now actually we've even evolved in terms, I don't even think we have a gun control paradigm anymore. We've moved to the sort of gun safety paradigm, which is much more solicitous of gun owners and of the rights of law-abiding citizens to own guns, and focuses much more on restricting access by criminals and the insane and dealing with illegal gun markets. So we have in fact evolved even in terms of how we think about the gun regulation side of the equation. But yes, for most of the 20th century, it was either we need to get rid of a lot of these guns or we need to protect these guns. And if it's a collective right, then there's no individual right. You have no day in court. If it's an individual right, then you need to have your day in court, and it needs to be protected the way we protect any individual right. And the reason we get that language is there's a Harvard Law Review article written by a judge of the Maine Supreme Court, Lucellus Emery, I think is his name. And he argues that it's basically a collective right, and it influences a generation of legal scholars. And it is pretty much how people think about it until the modern gun rights movement really begins to crank out its own version of the history from about the 70s and 80s on. And eventually that's the version of history that the Supreme Court under Justice Scalia adopts in District of Columbia v. Heller, a case from 2008.
Which is the next thing I wanted to talk about.
Isn't it amazing?